Salvatore Agostino, Assistant Commissioner of Tenant Protection and Buildings Marshal. I'm joined by my colleagues, Sarah Desmond, Executive Director of the Office of the Tenant Advocate, and David Hendershot, Assistant Chief Plan Examiner, to discuss tenant protection plan requirements for occupied buildings and protecting residential tenants during construction in general.
We're going to be talking today about the requirements of tenant protection plans, or TPPs, for work in residential and mixed-use buildings that contain at least one occupied dwelling during the construction process, or in certain cases when occupants have moved in after construction reaches a certain point. Attendees will understand when a tenant protection plan is required as opposed to an occupant protection plan, and will receive an overview of the 7 essential elements that comprise a TPP as set forth in NYC Administrative Code 28-120.1. The course will discuss recent and upcoming changes to the TPP and DOB Now, which is the online DOB filing system, inspections and auditing process, and how acceptable TPPs must be specific to that job site. You'll also learn about recent updates mandated under Local Law 154 of 2017, Local Law 106 of 2019, and Local Laws 116 and 118 of 2019. The objectives of the course: you'll be able to explain what a tenant protection plan is required and when it's required, as opposed to an occupant protection plan. You'll be able to review the 7 essential elements that comprise a TPP and describe the level of detail and site specificity that's required for an acceptable TPP. Participants will discuss recent changes required by new local laws impacting tenant protection plan content and procedures, and you'll be able to identify best practices with respect to tenant protection and be able to distinguish between an acceptable and an insufficient tenant protection plan. I believe that brings us to Sarah's portion, so I'll sign off and we can pass over to her.
Good afternoon. My name is Sarah Desmond. I'm the Executive Director of the Office of the Tenant Advocate here at the Department of Buildings. Thank you all for joining us today. Legislated tenant protections were introduced as a result of tenant harassment that includes interruption and denial of essential services, creation of unsafe living conditions, which could include conditions such as blocked egress, compromised fire protection, or decreased building security, and also because of the effects of byproducts of the building process: noise, dust, fumes, debris, etc. In 1984, DOB issued Directive 1, which laid out the 7 essential elements of what was then called the Tenant Safety Plan and is now known as the Tenant Protection Plan. In 2008, the TPP was codified in the Building Code using the same 7 elements that we use today. David, in his presentation, will review those essential 7 elements in detail. Of note, in 2016, DOB also first created the standalone TPP-1 form, which is accepted for biz jobs in buildings with 1 or more occupied dwelling unit during construction. So what you see here is an excerpt from the Directive 1 of 1984, which identified the 7 essential components of a tenant safety plan. You'll recognize them as similar to the 7 essential elements of the current tenant protection plan. So the next 3 slides we're going to show you will actually show actual photos that were taken during TPP compliance inspections that were taken by the Office of the Buildings Marshal Inspectors team. It's meant to illustrate to you why TPPs are necessary and why residential tenants need to be protected during construction. So in the photo on your screen, you'll see this is an actual photo that was taken. You have flammable debris and garbage that's blocking the egress path. You have compromised fire rating on the right. That will necessitate temporary fire protection or a fire watch. In this photo, you can see an ineffective dust barrier that is barely being held up, that is not sealed, that does not keep the dust from penetrating the public areas of the building. You can see the misplaced exit sign to the right as well. And in this third photo, you can see a number of hazards that including the open wood joists that are presenting both a fire hazard and noise problems, the excessive debris that's been allowed to accumulate. And so it's worth noting that all three of these photos were taken in occupied buildings with obvious construction underway. So one of the most common questions that we receive is, when is a TPP required versus an occupant protection plan? So the tenant protection plan is required when you have one or more dwelling unit that will be occupied at any point during construction, even if that construction is in a non-residential portion of the building. An occupant protection plan, on the other hand, is prepared for a non-residential project. It's not filed with DOB, but it must be available on site. The presentation today will focus exclusively on TPPs. We will not cover OPPs. And here you can see the building code section 3303.10 that sets forth the requirements of the OPPs versus the TPPs. So tenant protection plans have evolved due to the requirements of local laws over the past 4 years. Most notably, we have Local Law 154 of 2017, which reformed the TPP and set mandatory inspection requirements. Salvatore Agostino will discuss the TPP inspections later in his portion of the presentation. Local Law 161 of 2017 created the Office of the Tenant Advocate. Local Law 106 of 2019 shifted the requirement to file the TPP to the RDP that was hired by the general contractor. Local Law 106 also increased the inspection mandate to be 10%. And following that was Local Law 116 of 2019 that required that the TPP be submitted prior to permit, as opposed to prior to approval. I'll discuss Local Law 116 a little bit further in the next slide. And then finally, Local Law 118 of 2019, the TPP requires both the owner and applicant to sign the TPP, and it has it provides for increased penalties for failure to file a TPP, for up to $10,000 for the first offense and $25,000 for subsequent offenses. So Local Law 116 of 2019 moved the tenant protection plan to become a prior to permit requirement. For biz jobs, that means jobs that were effective, it went effective as of November 10th, 2020. For DOB Now filings, it was effective December 28th, 2020. TPPs are not reviewed at submission, but are subject to random audit, and where violations are issued by the Office of the Building Marshal or other DOB enforcement units. The Office of the Tenant Advocate also recently launched a TPP audit team that performs audits on biz jobs that were filed post November 9th, 2020, and for DOB jobs filed after December 27th, 2020. If you have a job that's subject to an audit that was filed prior to those dates, it will be returned as before to the borough where it was audited by the borough plan examiner, where it will be audited by the borough plan examiners. You should contact the respective borough plan examiner for guidance. And at this point, I'm going to turn the controls over to David Hendershot, who is the Assistant Chief Plan Examiner, who's assigned to oversee the OTA tenant plan exam unit. Sorry.
Hi, everybody. Thanks, Sarah. I have a few preliminary thoughts about the whole process of changing from a prior to approval to a prior to permit item. And that's a significant change because the TPP is no longer submitted by a representative of the owner, but rather a consultant of the contractor. And the fact that it was shifted to a prior to permit item allows the contractor and or his consultant to really think about the job, think about the scope, create a plan of action, not only for the construction, material ordering, having crews on site, all those things that we normally do, but also how they're going to protect the people who are still in the building while you're doing that project. So it's become very important, and it will be considered to be very important for any jobs that are audited, that the tenant protection plan be very detailed and site specific to that particular job. With that said, I'm going to come through with a fairly straightforward presentation of the 7 different elements of the tenant protection plan, and then I'll provide some examples that we've seen come through and make a few comments about those things, and hopefully it'll become a lot clearer to people as we continue with this process. So as you can see on the screen, the 7 essential elements. Number 1, make sure that you maintain legal egress for all occupants of the building. Number 2, maintain fire safety. Item number 3 and a subsequent item 3A was later added to the TPP1 form after it was originally issued, was to comply with the health requirements, and that includes lead and asbestos abatement. Number 4, comply with the housing maintenance code requirements. Number 5, protect areas of structural work and any areas that are affected by the structural work. Item 6, comply with noise reduction and control requirements. Item 7, maintaining essential services, or if you have an interruption in that service, then describe what are they going to be, etc. So item number 1, maintaining egress. These are some examples of the things that will be looked for. You want to describe how it's going to be maintained. You know, a lot of the audits that we've conducted so far in the TPP audit unit have been relatively simple applications for renovating an apartment, say, so that the egress wouldn't necessarily be affected to a great deal, other than making sure that a lot of dust and debris don't get tracked through the hallways, that sort of thing. Make sure that you've got your dust barriers at the doors. But the egress itself wouldn't usually be affected by one of those smaller projects. However, for example, if you were doing multiple floors of a building and some of that work involved putting one of the stairs out of commission for a while because it required repair or railing replacement or something like that, then you would definitely want to describe somewhat more detail about how the egress is going to change. And in that case, we'll talk about it a little bit more later on. You probably also want to provide some diagrammatic floor plans to show how that egress is going to change. Going on through the list, if any egress is going to be blocked, then you have to describe the alternative egress routes. Your phased floor plans may be required. If any egress path is in the construction area, you need to describe how it's going to be protected, maintained, and cleaned. You also need to describe how the construction area is going to be separated from the occupied dwelling units. I already mentioned plastic barriers, etc. In a few cases that we've seen, folks are actually changing the location of an apartment entryway. I think that photograph that Sarah showed where the corridor had been partially demolished to create a different entry location, that you're going to need to describe how that opening is going to be protected, or if a fire watch is required due to an unprotected or compromised egress path. Here's an example of one that we had seen, and I'll ask you all, if you wish to read through this, or while I'm reading through it, then type into the Q&A any comments that you think you might have as to whether or not this is an acceptable one. This one simply states, at all times in the course of construction, the egress starting from the second floor or occupied apartment will be maintained. no construction material, debris, or equipment to obstruct the tenant egress at any given time. When vendors are making deliveries, the material shall be taken to the area of construction without any delay that will cause an obstruction to the means of egress. When removing rubbish from upper floors, it should be taken out immediately. And then finished work in the hallways that affect the tenant's egress shall only take place when tenants confirmed that they are not home. So if anybody has any particular comments about this, please share them. In the meantime, I'll start with my own analysis of this, which I would have to say would start with the fact that it's not written very well. There are some grammatical errors and whatnot that make it a little bit difficult to understand what the intent was. But in addition to that, it's a little bit vague. It doesn't really describe how any existing element is going to be maintained properly. Looking at the last sentence, finished work in the hallways shall only take place when tenants confirm that they're not home. That sounds like a proposition that's very difficult to enforce, for example. So I'm not sure that you would want to be so confident in that particular fact. So it sounds as though the scope of this job involves working in the public hallways. So without saying how long that's going to take or exactly what's going to be happening, it's difficult to know, whether or not it's even going to be possible for tenants to be away long enough for this to happen. So I think that this just needs to be somewhat more specific. And it's difficult for us as an audit team to be able to say exactly what is necessary for this person to say unless we look at the plans for the construction itself, or any case where you might have diagrams included with the TPP, then we could look at those sorts of things. And in a way, it's also difficult for me to explain how this could be made acceptable without being able to show you the drawings as well. So we're a little bit hesitant to give you examples of things that are quote unquote acceptable because it might be acceptable in one case, but not in another case. The scope of the work might be simple in one case and not so simple in another case. So this is just a general discussion of making sure that you think about, your contractor thinks about exactly what is going to be happening and say that in the tenant protection plan. The next item, maintaining fire protection. Again, harking back to Sarah's slides showing places where hallways have been demolished in part. There's also cases where pipe chases that are fire rated are being compromised during construction. Sometimes a stair enclosure might be modified. Floor and ceiling assemblies. Again, remember looking back at Sarah's picture of that apartment renovation where all of the existing ceilings had been removed, leaving only the exposed wood joists. I think that's a clear case where a fire watch would be required in order to make sure that any small fire that might be caused, whether electrical in origin or otherwise, in that apartment that was under construction, had somebody there to notify anybody as needed before all that exposed wood caught fire. Fire extinguishers are required on the site, so you should say that, say where they're going to be. If you have any related diagrams, show them Any sprinkler or standpipe system modifications should be described. Any service interruptions for those systems should be described. That would be in the separate service interruptions section. And this particular issue can apply to all job types, not just the sprinkler or standpipe applications. So in one way or another, you'll need to be able to say that the sprinkler or the standpipe system is being affected. It could be to describe the work itself, or you could refer to a separate TPP that would usually be required for those jobs. Once again, if a fire watch is required due to unprotected or compromised fire protection, then please say that with details about it, when they're going to have to be there. Here's an example of the fire safety submission. All precautions to be observed to maintain fire safety, as well as additional safety measures necessitated by the construction, shall be strictly observed. 2-hour fire-rated wall and fireproof self-closing door to be erected in the hallway between the tenant's apartment and the area of work. In any event, any fireproofing material adjacent to the occupied apartment is being removed. A fire guard shall be present at all times while work is being done and the fireproofing material is being replaced. Again, everybody feel free to add any comments in the chat as we go, or any questions that you might have. In general, I believe this one's fairly close to being a good example. Going through the 3 sentences, the first one is clearly a little bit vague. You know, all precautions to be observed is not really the kind of language that we would like to see, and that will satisfy these requirements. This description of the fire-rated wall being put in place to protect the hallway is good, and that's a good example of what you should be looking for. The last sentence, again, is somewhat vague, just saying, in any event, any fireproofing material adjacent to the occupied apartment is being removed, etc. As I was saying before, since this is a prior to permit item now, that the contractor is supposed to be considering these sorts of things that are going to occur before submitting the TPP. You know, consult with your consultant or work with your construction team to establish, you know, how much fireproofing is going to be removed. Is any of it actually going to be outside the apartment in the public ways? Please state that. The tenants themselves, of course, don't have access to the drawings that are being done for any particular job, nor would they necessarily be able to understand those drawings even if they were to have access to them. That's why these verbal narratives and simpler diagrams are important to provide for people to understand how they're going to be protected during the construction process. So please keep that in mind. Item 3 and 3A, comply with health requirements. This is a big one for most people. I've experienced construction in the apartment below me. I'm sure that many of you are very familiar with the issues, both as a representative of a client and perhaps as somebody who's inspecting things in the field, et cetera. So please be as specific as possible about how you're going to keep the dust and the debris and the fumes and et cetera from getting out of the construction area, and state the results of the asbestos testing. You know, many people don't realize that before you even file an application, you should have the asbestos testing already completed, because part of the application process is to indicate the control number for the DEP form that you obtain after having that inspection done in certain cases. If it's exempt, Any building built after 1987 is not supposed to have any asbestos in it. I can definitely say that. Nobody has to worry about it. Also, if you do have asbestos, then please indicate any action that might need to be taken if additional material that hasn't been abated yet is encountered during construction. It's difficult to anticipate some of these things. You open up a chase and you find out that all the piping has asbestos insulation on it. It's not a good thing. So nobody knows what's going to happen until they can see it, which might be a good reason to do some probes before the construction starts. But the tenants need to know that they're protected. There's federal requirements for testing of lead, making sure that it's abated during the construction process. We're all probably pretty aware of some serious issues that have been raised in many buildings in New York City regarding this issue. So state any lead testing results or indicate how any lead discovered has been or will be remediated. Again, for buildings of more recent construction date, the lead in paints has been removed. But for any building that's built probably before the 68 code, although you'll probably want to do your own due diligence on this, you won't have to worry about it. Or you would have to worry about it if it's an older building. Here's our example for the health requirements. All construction work shall be confined to the interior of the apartment, which will be unoccupied during construction. That's actually an important point to make. Sometimes people actually do continue to live in their apartments while some work is being done. For example, if you're just having a kitchen renovation done and you're going to eat takeout for a few months, then that's certainly possible. But if you are in a case where that happens, then you need to identify that on the TPP, make sure that people know that the owners are going to be in residence. At no time will construction block the hallway, other public spaces, basement, or means of egress. All construction-related matter will be confined to the work site. The apartment entrance will be protected by a zipper cover at all times and will be kept clean. A sticky mat will be placed at the apartment entrance. An air scrubber with HEPA filters will be on during all working hours. Public hallways will be vacuumed with HEPA filter vacuum, mopped with a wet mop after each material removal, and at the end of the workday at 3:30 p.m. or at any other time during construction as needed. So I think this is a pretty good example of health requirements, except for the fact that they forgot their asbestos and lead. So they would need to be including some indication of those two elements in order to make this acceptable. Otherwise, for a relatively simple job, this seems fairly comprehensive. I see this is actually perhaps a continuation of what we saw before. Health requirements dust to be confined. Oops, here we go. Dust to be kept to a minimum and removed after completion of work each day. I'm sorry, this is the second example. My apologies. Plastic covers shall be placed on apartment entry doors where work being done may cause excessive dust. Disposal of construction debris must be done in a safe manner. Construction noise will be ceased after normal working hours. Limit noise to acceptable levels. Maintain sanitary facilities. Control pests at all times. Number 5 there says contractor must comply with applicable laws relating to lead and asbestos. If observed, immediately contact owner or architect. I think you can tell that this one is deficient in terms of number 5, lead and asbestos again. At that point in the process, the contractor should know whether or not there is asbestos or whether there's been an ACP5 form saying that any asbestos is either not there, or an ACP 2021 saying that the material has already been abated before the construction starts. And again, it's advisable to say what will happen if additional materials discovered on site after the construction process has begun. There was a little bit of cross-pollination in that last one as well, where they mentioned things that weren't necessarily relevant to that particular part of the TPP, and we'll talk about that a little bit more. The fourth item is to comply with the housing maintenance code requirements. Just because the building's under construction doesn't mean that the owner can be slack with regard to keeping the building clean and safe for all the residents in the building. The construction here, in this example, construction is limited to the interior of the apartment, which will be unoccupied during construction. All building and sanitary services will be maintained throughout the construction with limited disruption of water service for a 4-hour period described in number 7. The water shutoff will be performed by a licensed plumber. Tenants will receive 72-hour written notice prior to the shutoff and will be provided drinking water on request. Materials to control dust dispersal are set forth below, as well as compliance with health requirements. Work will only occur between the hours of 9 a.m. and 4 p.m. by a licensed contractor. And I think in this example, it's clear that there's a lot of information provided that's relatively detailed, but not a lot of it really belongs in this section. So we're not counting words when it comes to a tenant protection plan. We're evaluating the scope. We're evaluating the provisions that are being provided for people to meet the requirements. So it's not necessary to repeat information from one section into another section. You can familiarize yourself with the housing maintenance code and put in any applicable sections, and that's it. Complying with the structural work limitations. If no structural work is proposed, then simply state that. If there's any structural work that is proposed, describe in detail how the tenants will be protected during such work. This is required even if the structural work is being done under a separate filing. As I was saying with the sprinklers and the standpipes, though, if it's acceptable, or if it is acceptable to refer in writing to the separate tenant protection plan for separate filings, and you should include that job number as well. Our example for number 5 simply says no structural work shall be done that may endanger the occupants. The flaw in that statement is simply that it doesn't say whether or not there's any structural work being done. It simply says that we're not going to endanger the occupants. So please, as per the previous slide, state whether or not there's going to be structural work done, and if it is, then provide information as necessary to confirm that the tenants will be protected during that work. Another big issue during construction, as we all know, is noise. There is a separate noise mitigation plan that's required to be submitted to NYC Department of Environmental Protection, and you're required to maintain a copy of that document on the site. So for the TPP, you can simply refer to it, the noise mitigation plan, in writing as part of the TPP, or if you would prefer, you can describe the contents of the noise mitigation plan. But often, I'm sure it'll be easier simply to refer to that and make sure that people know that it will be made available for the tenant review. The last item, number 7, another extremely important one. There is also, well, we can move back a couple of slides that I missed. There are the example, but also this is just an excerpt from the DEP website showing that you can simply go online to submit the noise mitigation plan, and it also provides a link to the New York City Noise Code to show what those requirements are and how your construction project might affect those. The example for this one, construction noise shall be limited to that permitted during the permitted construction hours of 7 a.m. and 6 p.m. on weekdays as per the noise code. Contractor to develop a noise mitigation plan prior to the start of the work. So I think this is generally acceptable. Describe essential service interruptions. This is another important one. Almost all applications require some interruption of essential services such as water, electricity, and gas. Elevator service is also considered essential for accessibility reasons, although elevators are typically filed separately. Describe all anticipated essential service interruptions. You know, what kind of interruption is it going to be? How many interruptions? How long is it going to be? Notify the tenants and other affected parties, and to describe any sufficient alternatives to be provided. You know, if your water supply is going to be out for 3 days, then what are people going to do about water? If their heat's going to be off for a month. In our last example, where heat, hot water, cold water, gas, electricity, and other utility services are provided in such building or in any dwelling unit located therein, the tenant protection plan shall specify the means and methods, and so on. You can tell that this one is simply repeating some of the requirements that are given in the administrative code or in a service notice or some other outside source, but it's not actually providing you an example of, you know, what's going to happen on this particular job. It needs to be specific as per what was mentioned before. Here's an example of one that is fairly comprehensive and reasonable. Temporary disruption of hot and cold water services for the installation of a new water shutoff ball valve for a kitchen and bath fixture and PTAC unit upgrade. Expected duration of the temporary water service shall not exceed 4 hours. Work coordinated with the building superintendent. 72-hour notice to the tenants. Flyers will be taped in the lobby and hallways. No other services will be disrupted. Only the service elevator will be used to move construction material, so they're not anticipating any passenger elevator interruptions. And the contact number for super will be clearly posted on each floor. So some tenant protection plan takeaways. Make sure that it's detailed. Make sure that it's site specific. Don't use generic terms such as code compliant, protected in accordance with law, legal, approved, etc. And make sure that you address all standard elements, even if they don't apply to your job, and perhaps especially if they don't apply to your job, you need to say that. As I mentioned before, in some cases, the buildings are granted partial occupancy for dwelling units while construction is completed elsewhere in the building. Oftentimes, you'll see mixed-use buildings where there's work on the commercial spaces while people are still living in the building. We've got Building Code Section 3303.10.1. You're required to put a TPP in place as soon as any dwelling units are occupied in any building that's still undergoing construction. That's true even if construction isn't occurring in the residential portions of the building. Submit that to DOB now. As Sarah mentioned before, the TPP is not something that's being reviewed by plan examiners anymore, but it's still required to be provided to the DOB for record and potential audit in case there's any violation, stop work order. Sometimes there might just be a random audit, certain jobs. A big question that comes up very often is whether or not any kind of a floor plan is required for a tenant protection plan, and it can only be said that it has to be something that's in the professional judgment of the person who's submitting it. Simpler jobs can usually be handled with a narrative. More complicated work scopes with multiple phases or actual interruptions of egress paths for certain periods of time will, I would say, definitely need a floor plan in order to explain how the egress is being rerouted. If you're blocking or closing a means of egress, then the plans have to show that modified egress plan and temporary signage to redirect tenants to the modified paths. Phased construction plans show the varying egress paths, signage, etc., as each phase is undertaken. And as I said, the contractor and consultant are responsible for determining whether or not the floor plans are necessary, subject to audit. If the situation in the field changes somehow, if you end up having to interrupt services that you didn't think you were going to have to interrupt, or some structural issue comes up, you need to amend the tenant protection plan to show those additional elements. At the same time that work is going to be done, preferably before. Amendments to prior to permit TPPs aren't going to be reviewed by the DOB, but they must be submitted for record possible audit. And amended TPPs have to be available on site as soon as they're necessary to reflect the actual site conditions. Now I'll pass it back over to Salvatore Agostino now for discussion of the plan enforcement. Thank you.
Thank you, David. I'll take you through the rest of the presentation and discuss enforcement of tenant protection plans. There's several new initiatives, many coming into play since 2017, and the 2019 local law packages for tenant protection. One of the most significant ones is the requirement for notice 72 hours prior to commencement of work. The contractor must notify DOB. There is a portal that a contractor owner can use to notify us. Failure to notify will result in a violation. It does not result in an immediate stop work order, but it is a violation. So notifications and failure to notify are always undergoing random audits. Posting of the TPP inside the building, it must be available and posted upon the request of the tenant. The TPP notice must be posted at all times. It must be posted in a reasonable area at a reasonable height so tenants can read it, and distributed to the tenants. It can be distributed various ways. We've seen it distributed via email with receipts in case there's a question about it, distributed by mail, distributed by sliding it underneath the tenant's doors. But you must keep a record of how it is distributed, because if it is called into question, you should be able to show the department and oath court how you were able to distribute it and that you actually did that. Notification to the tenants of the TPP, right? So there's a standard form available, which will be up on the next slide. That form is available on our website. Use the standard form and you won't have any issues. We've seen variations of that form and things are inevitably left out. So use the standard form. It is available. It makes it easier for the tenants to understand it, and also legitimizes it. If you can point towards the tenant and tell them, listen, go to the DOB website. We use the form that's required, and they can see that sample. It helps you to have a better interaction with the tenant when you can tell them that you're using the form that was provided by the city. We also conduct site inspections in response to complaints by the public, as we always have. Site inspections for TPP compliance is something that is required by local law. And again, we inspect both the jobs that notified us within 72 hours, and more importantly, the jobs that do not notify us. If a job has not notified us, they are 10 times more likely to receive a stop work order. So the jobs that are notifying us seem to be in compliance and they're trying to follow the rules. Many of the jobs who fail to notify us are not notifying us purposely. So, and again, those will result in stop work orders if they're not either the TPP is either insufficient or not complying with the TPP. Violations for an insufficient TPP are 10,000 for the first offense and 25,000 for a second offense. So it's a significant fine. And when audits are conducted by our plan exam team, an intent to revoke letter will be sent out for a failed audit. And this is the sample TPP notice. Again, use this form. It's been on our website for the last 4 years. If you use this as well as Safe Construction Bill of Rights, the standard forms, it will help you to get through the process. Real-time enforcement unit was local law 188 of 2017. This unit monitors occupied buildings for construction work of 10% or more of the floor area. They inspect immediately hazardous complaints for work without a permit within 12 hours. DOB has created a notification form which will allow owner to send us that notification when conducting that work. The Safe Construction Bill of Rights, which we mentioned before, is actually part of the Housing Maintenance Code, although both DOB and HPD enforce this requirement. The Construction Bill of Rights must include several factors, and there have been some questions so far in the chat box about whether the Bill of Rights and the TPP notice are redundant and they have some of the same items. Yes, they do, and that is purposefully done, right? So the idea between the Bill of Rights and the TPP notice is to educate the tenants of the work that's going on, how long it will go on, who's doing the work, who to call if something's going wrong. And there are 2 separate and distinct forms for this, and they each cover different areas. There is overlap, but they do cover separate areas. You do have to have both of them posted and distributed. So the Bill of Rights has to include the description of the work being conducted and the specific location. So what that means is floor, unit, common area, right? It has to say it's specific. It can't just say, second floor. If it's the entire second floor, it should say entire second floor. If it's only one unit on the second floor or a common space on the second floor, you should indicate that. Well, you have to indicate that. It has to indicate the hours of construction work. If the hours of work or any of the items change, you have to go back and change the Bill of Rights. You can't leave it for the initial draft that you put on a couple months ago when you've now amended the job, or site conditions have changed, or there are other issues that had come up, or damage that occurred during construction, which now has to be addressed. So if the location and type of work and scope of work changes, you need to go back and amend all of these other forms as well. A projected timeline for the completion of work. Timelines change, we understand that. But again, if your timeline changes, go back and amend the form. Description of any amenities or essential services that may be unavailable or interrupted during work, and a plan to minimize the interruption. So if you're assuming to have plumbing interruptions where you have water and waste interrupted for a number of hours, and then that turns into a number of days, you need to notify the tenants that your initial estimate has been changed, and it's gone from hours to days or now weeks. Contact information. So that means a phone number for the agent or the owner for non-emergency matters. So those are general concerns. And for emergency matters, like essential services that may be interrupted overnight or on a Sunday. So you have to have the contact information for both your non-emergency line and your 24-hour, 7-day-a-week construction emergency. And that's generally going to be the same emergency number that you have on file with HPD. This is a sample of the Safe Construction Bill of Rights. Use this form. Do not create your own. Use the standard template. It allows our inspectors to recognize it and allows tenants to recognize it, and everyone that's concerned with it or that's looking for it to see this standard form that's on our website and on HPD's website as well. It lists everything that you need. You can fill in the blanks so you don't leave anything out. If you create your own form, you will inevitably lose something or leave something out, and you may have an issue for that's for no reason. If you use our standard forms for both of these 2 items, you'll be much better off. It's also available, the notice in different languages, telling tenants who to call, what the notice says, what it's supposed to contain.